Part 1. The Nature of Bondage. This presentation is put forth as a brief yet comprehensive overview of the history and legal structure of how we have become the indentured debt slaves of the world system. It will also integrate broader concepts of an esoteric and multidimensional nature that infuses the world system, unknown to most, as it follows the esoteric maxim of hidden in plain sight. The word indenture means to attach something of value to a contract, whereby the attached value becomes the bonded surety for the performance of the contract. We have all heard the term indentured servant. This refers to a man or woman who voluntarily attaches his labor and life to a contract to serve for a period of time in return for some form of consideration as reciprocal value. The contract forms a trust. The life and labor are the initial corpus of the trust, and the party providing the immediate value in exchange for the future labor is the trustee, and holds the value within the trust for a named or potential future beneficiary. An example is when a man wished to come to America in the 18th century, and during that time it was gender-specific to men only, and would agree to be an indentured servant to pay for his passage to the New World because he did not have money to pay for the passage. So instead, he exchanged the value of his future labor for the value of the passage on the ship. The contract of this agreement is an indentured grantor trust. The man is the grantor, and he places his future labor into trust as the initial value and property to be held in trust. This creates an indenture. The interest or future labor thus held can be sold as a means for the ship captain to be paid upon delivery of the man to the American shores, and that end user is the beneficiary. A plantation owner or other principal buys the contract. The captain is paid, and the new owner now has an indentured servant that will work for him until the terms of the arrangement are fulfilled. If that total payment is extended longer than the contract calls for by additional charges being applied for upkeep, rent, food, or whatever else, the term might be extended for a longer period, or even indefinitely, as summed up in the lyrics of the song 16 Tons and the line, "I owe my soul to the company store." The story you are about to read is about how the souls of the entire world population have been bonded, indentured, and sold to the company store, and just exactly what that company store is and who owns it. A grantor trust is essentially an indenture that bonds the value of the initial grant into the trust body, and now the legal title and control of the trust is vested in the trustee, and the equitable value is vested in the beneficiary. In the case example, the ship owner is the trustee of the beneficial rights and interests of the future labor, which in turn can be sold or exchanged forward to someone or some group on the other side of the passage to America to take control of the indenture trust corpus, and thereby become the beneficiary. That person or group is also, in effect, the beneficiary, and when the trusteeship and beneficiary are vested in the same person, the trust collapses due to a merger of title. Now, the plantation owner holds full title to the future labor of the indentured servant. In this manner, when the man wishing passage enters into this agreement, his future labor is hypothecated in a form of monetization. The trust agreement becomes a negotiable instrument that can be bartered, traded, or sold to another party upon arrival in America. This is the basis for the bonded indenture relationship that almost all humans are held within with respect to their government and central bank in a network of corporations across the world in the guise of nations. Such a relationship is voluntary and yet cannot be broken unless and until the obligations attached to the indentured trust servant are settled and extinguished. Therein lies the rub. The pledged value exists in the future, but the bonding is established in the present, and if the future settlement is never achieved, the bonding/bondage endures from birth until death. The function of creating any kind of trust creates a split title, as there are two titles in a trust, the legal title held by the trustee and the equitable title held by the beneficiary. This point of a split title trust is important to understand because when we speak of our current status and attachment to the public debt system, we are speaking of grantor trusts and indenturing of future value. An additional point within the definition and function of an indenture is that it creates a form of bonding of value, and bonding means a secured interest in that asset or value which is attached to the debt or obligation. When we speak of secured interest, we are also including the context of a guarantor of the debt, stated as a bonded surety. Such a trust has been created for almost every human being in this world, and this function is hardwired into the standardized process that meets and greets a newborn baby anywhere on the planet. The primary focal point for such a creation of bonded surety status ensues from the mother, unbeknownst to her, who dutifully follows the narrow pathway provided for her as she is cuddling and enjoying her newborn son or daughter. To be free of that bondage, we must collapse the grantor trust created by our mother that she established as the original grantor. These points will be key components of our discussions in this document. On the record of live birth, the functions of the mother constitute a registration in which she is characterized as the informant, which literally means she is putting her newborn into form. As the newborn grows into adulthood, he or she will thenceforth have to place data into the myriad of forms in the public domain to get anything and everything desired and required for life. The trust created splits the title and attaches the baby to the trust as an indentured servant, with the hypothecation of all future labor, value, and wealth against the future performance of the indentured servant. This creates a public person, and all actions we take in the public are structured so as to maintain the public persona as a debtor facility. Every instance of creating a document with the name of the person on it become negotiable instruments, and all such negotiable instruments issued in the all-caps name of the all-caps person are done as monetized debt. Our future value is monetized via the public persona, known in legalese as an all-caps person, in the name of which all public commercial paper and negotiable instruments are created, monetized as debt, and circulated in the public as currency. Once the original person is created, every instance of the issuance of any documentary draft are considered publicly circulating commercial paper that perform as currency as they flow through the system like the current of a river or stream through its banks. They are also considered and acted upon as bonds, and a bond is evidence of both a debt and a private trust relationship. That persona is the all-capital letter name United States person, created as a franchise of the bankrupt all-caps United States. The United States is a corporation that was formed as a government services entity after the Civil War between 1866 and 1878. A government services corporation is not a lawful government. It is a municipal corporation that functions in commerce, not law. The entity incorporated and named United States and later all caps United States was the municipal area of Georgetown in the District of Columbia. It was placed into bankruptcy on March 9th of 1933 and was thereafter and to date controlled as a foreign military occupying force under international rules of bankruptcy, admiralty law, conquest, treaties, and global monetary policies. The occupied country was the original organic the United States of America, established as a perpetual union by the Articles of Confederation. This is, of course, a complex structure beyond the scope of this paper to fully describe, but a synopsis understanding is imperative if we wish to understand our world system today and how we are in bondage to it as perpetual debt slaves. Equally important with this understanding is how do we effectively remove ourselves from this status of bonded surety to a bankrupt franchise. To understand all of this, we must proceed with clear definitions of the words and phrases we are using, such as debtor facility, franchise, bonded surety, commercial paper, negotiable instruments, uniform commercial code, monetized debt, and others, all of which shall be defined and discussed herein below. Additionally, knowing how some of the complete distortions pertaining to the founding of the country, variously known as the United States of America, United States of America, United States, and other variants are equally necessary. Suffice to say, they are not the same thing, as will be discussed. All in all, the understanding of definitions, legal terms, root etymology of words, and other methodologies of bait-and-switch tactics done over the centuries to achieve confusion, obfuscation, and cognitive dissonance are essential for us to understand the nature of our condition in this reality and how to find the pathway to freedom and release from bondage. This document will provide the framework and details of how one can then undertake the research, knowledge development, and practical means to a true solution to achieve such freedom. What's in an all-caps name? To begin, what is a debtor facility? It means that it is an entity that is used to facilitate the issuance of some form of documentary instrument that is a debt, that then becomes currency to circulate in a commercial system that most refer to as money. That system is controlled by something known as the Uniform Commercial Code, a modern system that was actually created in Roman times some 2,000 years ago and evolved through medieval times as the law merchant, also known as Lex Mercatoria. Both of these terms and the function of mercantile law harkens back to Roman times and Roman civil law, which itself is an extension of the law of the sea, or in other words, maritime law. The UCC is the final modern derivative of these millennia-old forms of law that pertain to merchant ships, vessels in commerce, insurance, and bonding of cargo held in the hull of such ships. In short, the modern UCC system defines relationships between debtors and secured parties and more subtly establish bonded surety attachments to the collateral or cargo thus insured and secured. Any and all publicly issued documents such as tax, utility and service bills, court orders, traffic citations, medical records, and others are all forms of commercial paper that have the all-caps name on such documents as the debtor and the party to whom the bill is payable as the secured party. Because these are all issued pursuant to the UCC, they are referred to as commercial paper. When commercial paper has two signatures on it, they are considered negotiable instruments, which means they can be negotiated from one party to another by being passed on, which is what is done with the Federal Reserve notes we call dollars. Notice the two signatures on every FRN, the Secretary of the Treasury, who is the secured party representing the creditor, the International Monetary Fund, and the Treasurer of the United States, who is the debtor, representing all the pledged collateral of the nation, including the people and their labor. In this relationship, the item, person, or thing attached remains the secured collateral, and as each negotiable instrument is passed from one party to the next, the party currently holding the instrument is known as the holder in due course. This is no different than when the man on the European shore placed himself into bonded indenture as discussed above, and upon arriving on the shores of America, the ship owner sold the interest in the indentured trust of his future labor to a plantation owner who thereafter can utilize the hypothecated labor and thus become the holder in due course of that indentured value. Thus, every U.S. citizen is designated as an all-caps person via the franchise with the all-caps name. In aggregate, they are bonded as collateral against the debt issued as commercial paper, negotiable instruments, and monetized debts, Federal Reserve notes, in the all-caps name of the franchise. The same is true in every nation in the world that has a central bank as a bank of issue, a bank that holds the exclusive power to issue money. Thus, when we are born and the original trust indenture is established, the all-caps person as the all-caps name becomes the primary nexus by which we are attached to perpetual debt from birth until death. Our status, by virtue of that attachment, is a bonded surety to a bankrupt franchise, an indentured servant by our own voluntary acts. That sounds complicated, but it is actually very simple and something we do every single day, all day long. Every time a piece of paper is issued with the all-capital name, or upper-lower case, which is just a variation of the same linguistic trick, as the named obligated party, we are using the facility of this entity to create monetized debt with said name as the debtor. This means it is the debtor facility. Still sounds complicated, right? It will become clearer as one proceeds through this presentation. But all should be advised to truly integrate this material takes time, diligence, and a commitment to release old belief systems and programmed limitations within our personal reality. This will be discussed further below, but it is important to note that this is the case. And any reactions one has to this information, whether anger, resistance, reaction, disbelief, cognitive dissonance, and other variations thereof, indicate coming up against programmed structures within us. Next, we ask the question, what is monetized debt? Monetized debt is created when the United States Treasury takes the aggregate total of its collateralized franchise and corporate subdivisions and issues bonds against the hypothecated value of the future work potential of the population so indentured. It then sells the bonds to the Federal Reserve, which in turn issues Federal Reserve notes that circulate as money. This is the function of monetizing debt and converting it into money. Everything that is issued in the debtor name, such as utility bills, traffic citation, court cases and judgments, tax bills, and medical records, are in fact forms of debt that will become part of the hypothecated value that is monetized so that they create currency as money. These forms of debt are bonds, and all bonds are evidence of debt and bondage. In bonded debt, there has to be a debtor as well as the entity, individual, or institution that provides a security or guarantee that the debt will be paid, known as a surety. Thus, we are the bonded sureties. As living beings, we are in fact the surety for all monetized debt issued in the name that appears to be our actual name, but is in fact a linguistic trick that converts a normal name into a franchise of a larger entity. That larger entity is the bankrupt United States. Thus the name, which is spelled as our name but is in fact not the same, is a bankrupt franchise, and we are the bonded surety to all the debt, seen and unseen, that is attached to that name. These names are called franchises because they are facilities by which we can use this system and participate in the field of commerce, so that we can eat and travel and purchase goods and pay our rent. The franchise is also considered a commercial vessel, indicated if we review something called the Government Style Manual, issued about every 10 years by the U.S. Government Printing Office, wherein it defines any name written in capital letters as a United States ship. But more insidiously, for every public instrument issued, there are, in fact, hidden bonds attached to the instrument that are never seen by the public. For example, when a court case is opened with the name as either plaintiff or defendant or indicted party, numerous bonds are issued that remain even after the court case is settled. In criminal cases, if the indicted party is convicted, a penal sum bond is issued to bond the surety while he or she is incarcerated. These bonds can last up to 30 years and are traded over and over again long after the prison term or parole or probation is served, and even after death. A bonded surety to the franchise is the purest form of bondage. How do we know the name is a franchise? The easiest and most self-evident way to know is to consider that the taxing authority for individuals in California is called the Franchise Tax Board, thus indicating that personal income tax in the state of California is really a franchise use tax. The difference in our case is that there is no determined time for the settlement of the debt, and as long as there are open accounts and bonds attached to the name for which we have volunteered to be the surety, we remain in bondage and servitude. More importantly, what we see in the public in terms of debt, money, and currency is only the tip of the iceberg. More insidious to this is the fact that for every unit of monetized debt as $1, there can be as much as 10 to 100 times more hidden bonds attached to each commercial instrument issued in the name. Such things as driver licenses, marriage certificates, deeds of trust, mortgages, birth certificates, and every form of registration have these forms of hidden bonds that are multiplied, traded, increased through mirroring in the creation of derivative instruments, and much more. The key to our status is that it is voluntary, whether we know it or not, and the entire world system is constructed to provide the illusion of choice because all of the detail is hidden in plain sight in all of the contracts, agreements, applications, accounts, and other forms of engagement that we enter into every day of our lives. This is perpetual bondage within the illusion of freedom from cradle to grave. The conversion of a proper name in the English language to an entirely different entity altogether as the name is known within and derived from something called the Justinian Deception. A definition of history. History is the record of a progressive storyline undertaken to establish a globalized system of law in order to therefrom derive a system called money for the singular purpose of establishing an artificial reality construct of ownership of the world's people and resources, so the people thus owned and controlled would be managed and directed for the purpose of extracting the world's resources to build a global prison into which the people are maintained in a perpetual system of cultivation and harvesting, along with another system called religion that was created in order to perfect belief systems so that the people would voluntarily bind themselves to the reality system and thereby accept the entire construction as justification for their existence being placed into their own self-created bondage and enslavement system with little resistance, rebellion, or objection. Let's reread the description of history using the underlined portion as one sentence. History is a progressive storyline for the singular purpose of establishing an artificial reality construct of ownership, so the people thus owned and controlled are maintained in a perpetual system of cultivation and harvesting with another system called religion, so that the people would voluntarily bind themselves into their own self-created bondage and enslavement system. In short, in fulfillment of the above definition, world history is the story of how all the people in the world have been placed into bonded servitude, which has been established as individual indentured trusts that bond their future labor to underwrite the perpetual monetized debt system. In order for us to understand how this works within the world system, we must first set the foundation by understanding some basics about the primary systems of law and money. Most of the world's people have little, if any, clue as to what these systems really are and how they have been designed to be the code of the matrix over the millennial process of history leading to today's world system. Law and money are the flip sides of the same coin known as history. Today's codified legal system is a hybrid system derived from origins in law. These origins include two primary areas of focus known as law and equity, but as well are interwoven with many other law forms and jurisdictions: civil, maritime, admiralty, commercial, and even kingdom and ecclesiastical. Law has to do with agreements, contracts, and the settlement of disputes, reparations for injuries, and penalties for criminal offenses. Equity focuses on issues pertaining to beneficial interests in trusts and estates. It also includes expanded issues in law that had to do with relative equitable interests from contractual agreements. When a contract includes fair and equitable consideration, the parties of the contract receive fair and equitable compensation for their interests during the course of the contractual arrangement or otherwise. Without fair and equitable consideration, there is no valid contract. A valid contract is one that is based on true equity and balanced consideration for all parties. Equity is balance.